All right, on the matter of People versus Rainer Reinscheid.
Good morning once again, Your Honor. Ron Career for Mr. Reinscheid, who's present in court in custody.
Good morning, Your Honor. Andrew Katz for the People.
Good morning. We are here on this matter for continued arraignment and on the People's motion to maintain the defendant's no bail status. And we will proceed with the People's motion first.
Thank you, Your Honor. The People have submitted various briefs, and we would ask the court to maintain the no bail status of the defendant for the following reasons. First of all, the legal standard, as the court well knows, is that the court must find, based on clear and convincing evidence, that the defendant has threatened another with great bodily harm, and that there's a substantial likelihood that should he be released on bail, he would carry out the threat if released. Well, there's more than ample evidence. There's an abundance of evidence of the threats the defendant has communicated. I know from reading the defense opposition, or one of the briefs they filed last week, they believe that the first email from the defendant to his wife on April the 26th is privileged. The People would disagree with that and state for the following reasons. One, new evidence yesterday from Detective Miller of Irvine PD, who is present in court should the court need inquiry, reveals that the defendant's wife never received the email communication from April 26th, the first one. In fact, Detective Miller is of the opinion that the email was somehow put into a draft box and that the mail was not sent. So if the mail was not sent to the wife and she says that she did not receive it, then there was no confidential communication and the communication is not privileged. Second, even assuming a court would say, well, you know what, the communication may have been sent or it was sent, the People would still maintain it is not privileged, that the defendant waived the privilege under Evidence Code Section 912 when somebody takes the substance of a confidential communication and relays that in another non-confidential communication, the privilege is thereby waived. And the substance of the first email on April the 26th, where he talks about killing the assistant principal, burning down the school, the gist of these arguments, of these threats, was conveyed both in the email he sent himself on April the 28th. That's the one where he talks about buying machine guns, killing the assistant principal, killing the principal, raping the counselor, committing violent acts of sexual assault, burning the school to the ground, killing hundreds of students, and then killing himself. Furthermore, in the email, which the court has, of July the 17th, that may or may not have been sent to 10 named individuals, the defendant again talks about how he had tried to burn down the home of the assistant principal and the school. Therefore, given that he has relayed the substance of the content of the original email to his wife, we believe he has waived the privilege. Finally, with regards to the emails, the People would say the point is almost moot anyway, because even if the court disregards the email to the wife on April the 26th, there is still an overwhelming mountain of evidence indicating the threats that this defendant made and the danger that he poses to public safety. In the defense brief that was filed this morning, the defense seems to be basically stating that these threats that are made in the emails are really nothing more than the fantasies of an anguished soul. Well, that simply isn't the case. The ancient Romans probably said it best when they said, in vino veritas, which means in wine there is the truth. We all know that alcohol doesn't cause us to say things we don't actually believe. Quite the contrary. Alcohol releases our inhibitions. It somewhat dissolves the filter that most sober people have between their brain and their mouth. And it is a very good window into the soul and mind of what somebody is thinking. And in the email that the defendant wrote to himself on April the 28th, when he talks about being on his second bottle of wine, and he lays out this plan, which I believe the title of the email is A Good Plan. And at the end of the email, he concludes that this is his plan. What a way to go out in this world. Start with the administrator, some other people at the school, burn down the school, kill hundreds of students, and then kill himself. So these threats must be taken serious. We need only look back in history to know that the threats, the musings, the fantasy, if you will, of people should be taken seriously. Perhaps people should have paid attention to the fantasies that James Holmes wrote about prior to going into a theater in Aurora, Colorado a few weeks ago, murdering 12 people in cold blood and wounding 58 people. Perhaps people should have paid attention to the musings of Eric Harris and Dylan Klebold, who blogged regularly about their plans to murder and set fires and things of that nature back in 1995, and they ended up going to their high school, Columbine in Colorado, slaughtering 13 of their classmates before killing themselves. If this was a case of just threats alone, obviously we wouldn't be here. But the fact is the defendant has acted out on these threats. And the fact that his acting out isn't catastrophic, he hasn't killed anybody yet, the house wasn't burned to the ground, the school wasn't burned to the ground, that's not relevant. He has started down a course of violence directed towards these certain individuals, and the evidence in this case shows that his behavior has gotten bolder. He acted on the threats. He's charged with 9 counts of arson, which, as everyone knows, the court must assume is true for purposes of bail. Well, that shows that these are not just mere fantasy and musings. He's acting out on what he's threatened. He's set 3 fires at the home of the assistant principal, 2 fires at the school, and the fires at the school, both of them actually burned the structure. The last fire that was set at the home of the assistant principal was July the 19th, 2 days after the July 17th email in which the defendant wrote to 10 people, soliciting them almost in a sense, you failed my son Klaus. To redeem yourself, it's time to go out and kill the principal and another named individual. So he's not, and the court should note that after that email on the 17th, over the period July 19th through July 24th, he committed 5 new arsons. And he didn't just stop, he was caught. So there's absolutely nothing to suggest that should he be released on bail, the feelings that he holds, the feelings he harbors, the rage, the anger, the resentment, the despair, the feeling of a need for vengeance against those people he holds personally responsible for the suicide of his son, namely University High School, the assistant principal, none of that has changed. And if he's released on bail, he will follow through with those plans. Well, the fact that he has made threats, acted out on the threats already, that alone meets the clear and convincing evidence standard, but yet there's still more. In addition to acting out on these threats, the defendant has actively been surfing the internet. And what's he been surfing? Well, on March 25th, May 13th, and May 24th, he did no less than 64 searches to obtain the address of the assistant principal, which he obviously did obtain because he committed the arsons at his house. On March the 25th, May the 3rd, May the 16th, and July the 5th, he did 40 separate internet searches on guns and gun purchasing laws. On July the 11th, perhaps most disturbing, he made 52 searches on the internet about C4, which is a military-grade explosive, other explosives, bomb-making tutorials, sites that talk about how to blow up a car, sites that talk about ammonium fertilizer, and everyone will remember that ammonium fertilizer is the same chemical used by Timothy McVeigh in 1995 to make a truck bomb with which he took down the federal building in Oklahoma City and murdered 168 people. So this defendant is not only made the threats, he's not only acted out on the threats, but now he's actively surfing the internet and learning about methods of committing mass murder.
Counsel, let me stop you. Were
Sure.
any of these items found in any of the searches, any guns, any fertilizer, any of the other things that he was searching for? Was there any tangible evidence of any of those things found in any of the searches?
In the searches that have been conducted at his home or
His
office?
home, his office, all of the search warrants that have been articulated in the moving papers, anything like that found?
Not at this time. but investigation is ongoing. And I'm almost done, Your Honor, but on top of all of this, the people believe what makes this case and this defendant even far more dangerous than what I've already expressed is the fact that throughout all of his emails, he has indicated his intent to end his own life. The court will recall he was initially arrested July 24th on only, I think it was 2 counts of arson. He posted bail in the amount of $50,000. On July 27th, when Irvine police went to his office, they saw on his computer a document he was working on, which the court has. It's an attachment to the declaration by Detective Miller, which is incorporated into the People's supplemental motion to maintain no bail status submitted 1 week ago. And it's a document that shows on July the 27th, the defendant was making a power of attorney to transfer to his wife control over all of his bank accounts, control over the matters relating to his children, the sale of assets, his home, his car, and furthermore, later that same evening, July the 27th, when the police actually rearrested the defendant, they found in his possession a brand new, freshly executed that same day, will and trust. This is a man who's ready to check out on life, and there's no amount of bail that can deter the threat or secure the presence in court of a person who's ready, willing, actually planning to kill himself. And the people strongly believe that this defendant is at the end of his rope. He has nothing left to lose. The vendetta that he has started against the assistant principal, other named administrators, there's no evidence to suggest those feelings that led to this personal vendetta have changed, and he's ready to end his own life. If he is released on bail, the consequences could be catastrophic. We would say, for public safety, that he should be denied the opportunity for bail at this time. I'll submit.
All right, thank you. Mr. Cordova?
Thank you, Your Honor. I am somewhat at a disadvantage because I didn't realize I would be arguing this case with a forensic scientist who was offered his opinion as to what alcohol induces. I'd rather speak to the law than some notion of what value there might be in the musings of a man fueled by a psychotropic drug, as a legal, but nonetheless psychotropic drug, as well as alcohol. So let's focus on what we know, the law. One of the interesting aspects of the prosecution's argument is that this power of attorney somehow is indicative of a desire to take his own life. Well, that strikes me as a very, very, very tortured argument when the power of attorney does not survive the demise of the person issuing the power of attorney. It is only good for the life, during the life of the person who has given the power of attorney. So to make the argument that the preparation of the power of attorney somehow speaks to the desire, the willingness of my client, Professor Reinscheid, to take his own life, is an absurd argument. Context is everything, Your Honor. And the context of this case are the facts of this case. This is not Columbine, Colorado. This is not Aurora, Colorado. This is not Oak Creek, Wisconsin. This is Orange County, California, and we have specific facts. Very interesting response given by the prosecution to the court's very trenchant question. What evidence, what items do we have that would show anything beyond mere ideation? Any preparatory steps? We don't have any evidence at this time, Your Honor. Well, I submit to you that Irvine Police Department is a very, very, very thorough law enforcement agency. That agency has done a search. That agency has served multiple warrants. While I understand that computer readings take time, the Irvine Police Department and the District Attorney's Office already know what physical evidence there is. And those agencies already know that there is no physical evidence to corroborate the theory.
Does physical evidence need to be found?
It does when the people are not only wrong on the law, they're wrong on the science and the literature. The suggestion implicit throughout the prosecution's briefing is that because Professor Reinscheid indulged in these musings, that these musings are somehow windows to his soul. The literature is very clear that, loath as we may be to concede the point, such homicidal ideation is very common, and it is common in normal people. So let's deal with the reality we have here. We have a father who has lost his son by suicide. He was not informed. I'm not faulting anyone for not sharing that information. I understand that the young man pleaded with the school authorities not to tell his father. For whatever reason, they abided by his request, and within 24 hours, a young life was extinguished. We have a man who is anguished. We have a man who has, for the sake of this proceeding, we must assume, we don't concede, the defense does not concede, but we must assume that certain acts were committed. And what were those acts? Well, let's see. The first alleged arson was of a pair of running shoes on the front porch of the assistant principal. The second was a stack of newspapers next to the garage. And the third was the arson of a single book without the use of accelerant. Your Honor, the statement that is attributed to, and we must assume is accurately so attributed to Professor Reinscheid, that I was not strong enough, has to be read in the context of what he said. There is no doubt that Professor Reinscheid is sufficiently able-bodied to have committed successfully the arson that the prosecution suggests was contemplated. He didn't, because he was not strong enough in the most negative sense of the word. He was not sociopathic. He is not sociopathic, and therefore he is bridled by that which a sociopath does not find himself restricted.
Isn't it a matter more of luck in one situation than not being strong enough? Newspapers next to a garage that are set on fire, there's no way to know that the garage is not going to take to flames and the whole house burn down.
I think it's more than luck, Your Honor, because there was no accelerant. The instrument of death attributed to Professor Reinscheid is a fire log. A fire log is used for a particular purpose. It is essentially a retardant material. It confines the fire to the immediate burning. It does not spread. That's why we have such conveniences. I am not minimizing the conduct alleged if Dr. Reinscheid is guilty of such conduct. And as the prosecution properly points out at a bail hearing, we must assume. We don't abandon the presumption of innocence. We simply put it aside for the purposes of this proceeding. The law requires clear and convincing evidence of a true, not an imagined threat. The prosecution ignores the variance between and amongst the various musings. In one email, it's death by machine gun. In another, it's death by hanging. There is no consistent thread. There is no acting out upon this ideation. This is an anguished soul speaking out, crying out, and in many ways engaging in a therapeutic exercise. Purge it from your mind. And we believe, in fact we know, that we have well-qualified experts in the field, not would-be forensic scientists arguing a bail motion, that speaking out, giving words to ideation is a means by which we cleanse ourselves of those less than salutary thoughts. Your Honor, prosecution suggested earlier, and I assume that it is now abandoned its position, faced with the reality, faced with the truth contained in Professor Reinscheid's wife's declaration. There is no access to a weapon, and indeed, Mrs. Reinscheid informs us that Dr. Reinscheid had no access to it, that she kept it in a safe deposit box because Dr. Reinscheid detested firearms. She's even offered to turn that .22 caliber, not an instrument of mass destruction by any means, but nonetheless, she has offered to turn that firearm over to the Irvine Police Department or this court if the court believes that it should be a condition of her husband's release. Dr. Reinscheid is not facing capital charges. He's not facing charges based upon the musings, the ideation. He isn't charged with a violation of Penal Code Section 422. He's charged with several counts of arson. I am not minimizing the conduct if it is his, if he indeed engaged in these acts, but what we have as a consequence of that behavior, of that conduct, is aggravated vandalism. We don't have any conflagration. We don't have any firestorm. It would be amusing, were we not in the solemn setting of a courtroom, to suggest that a firestorm could be started by a firing log. Your Honor, the prosecution has not met its burden, and I believe that the court must lawfully admit Professor Reinscheid to bail.
Yeah, thank you. Any final words, Mr. Katz?
Yes, I just, thank you, Your Honor, very briefly. I would just state, to suggest that from the email of the July the 17th, where the defendant, one of his statements is, I was not strong enough, to somehow suggest that he wasn't successful is absurd. He's not charged with murder, he's charged with arson. And in that, he was successful. After that email, he set 5 more fires at the home. In fact, the most serious of the 3 fires that were set at the assistant principal's home was the one that was set by the defendant 2 days after the email in which he said, I was not strong enough. So, yes, he was strong enough because he committed the crime of arson of inhabited residence. The arson he set 2 days after the email did, in fact, burn the structure of the home. It was just fortuitous that the fire did not spread and that the whole house did not go up in flames. I'm not a forensic scientist, it's true. I'm pretty sure Mr. Cordova's not a psychiatrist. But the only thing we have that's certain is the evidence before the court. The threats were actually made, they were acted upon, and the motivation for the defendant to act upon these threats has not changed. He never stopped the conduct on his own. He was caught in the act. And we think that the evidence in this case that he presents a substantial danger of acting out on those threats is beyond the clear and convincing standard that the court must find. We'll submit on that.
All right, is the matter submitted?
Yes, of course.
All right. This court has reviewed the moving and opposition papers and both of the parties' responses to the others' oppositions that were filed this morning. So I have had the time to go through all of your papers and all of your documents, and I have considered the argument of counsel here in court. The court does find the evidence clearly and convincingly supports the denial of bail pursuant to Article 1, Section 12C of the California Constitution, and therefore grants the people's motion to maintain the defendant's no bail status. Turning now to the arraignment. Are we prepared to arraign the defendant?
Yes, Your Honor. We would acknowledge receipt of the second amended complaint and ask that a decree of not guilty be entered as to each and every count therein specified. May I have a moment with Mr. Katz?
Yes.
We would also ask that a denial of the special obligation be entered as well.
All right, and what date did you want to set?
Your Honor, we would request, and I believe the prosecution has no objection, to the date of September 6, 2012 for a pretrial.
And counsel, that does require a 10-day time waiver.
Of course. Professor Reinscheid, you understand that you have a right to a speedy preliminary examination, which the legislature has defined to be within 10 court days of today's date. Are you willing to give up that right so that the pretrial herein may be held on the 6th of September 2012? Yes, sir. Do you understand that the preliminary examination must therefore, by reason of your waiver, be conducted within 60 calendar days of today's date, unless there is a further waiver of the right to a speedy preliminary examination? Yes, sir.
Counsel joins?
I do, Your Honor.
All right, then the pretrial will be on September 6th, 8:30, this department. Defendant is ordered to appear. That will be no bail, and the court will exonerate the bond.
Thank you, Your Honor, and thank you, counsel.
Thank you.
Thank you, Your Honor.
You said it? Get it?
Brittany or no, Jeffrey Dean?
You guys.
Hey, just FYI, we got a couple of traffic citations also that have been trained on. Yeah, we're gonna handle those. Gonna handle those? Okay.
Oh,